Good afternoon, everyone. Thank you for joining us for another Beale and Company webinar, the next in the series of our regular construction law updates. This webinar, as the title slide indicates, is in relation to the new NEC4 suite of contracts, which were published on 22nd June 2017, and focuses on the NEC4 engineering and construction contract for our contractor clients and friends. Yesterday, my colleagues Will Buckby and Andrew Croft gave a webinar in which they considered the NEC4 professional services contract from a consultant's perspective, and they introduced the NEC4 professional services subcontract. That webinar is now available to view through our website. So for those of you who don't know me, my name is Tom Pemberton. I am a partner in the Projects and Construction and Contracts Advisory team at Beale and Company. I'm joined by James Vernham, with whom I have presented a number of previous webinars in our Construction Law Update series. James is a partner in our Construction Dispute Resolution team. So the NEC describe their changes as evolution, not revolution, suggesting that the changes are largely improvements to reflect market practices and to make the forms more internally consistent. This is similar to the approach adopted in the other standard forms. Today we will explore whether the NEC's description of the changes is true, and to what extent the changes to the engineering construction contract in particular are improvements which will reduce the need for additional Option Z clauses. In the first part of the webinar, I will provide a very brief refresher on the NEC contracts and consider some of the reasons for the introduction of the NEC4 suite and the new forms which it includes. I will then touch upon the general changes, including use of terms, which have made to the NEC3 suite, many of which apply to the ECC as well as the other forms. James will then look in some detail at the changes to the provisions relating to programme, compensation events and dispute resolution. I will then provide an overview of the other main changes to the ECC, including those dealing with design, payment, liabilities and insurance, and additional clauses in the secondary option clauses, before giving us a brief snapshot of the NEC4 engineering construction subcontract and drawing a few conclusions. Given that NEC4 is a new suite, we are expecting lots of questions today. As usual, questions can be raised during this webinar using the interactive box on your screen. We will leave the questions to after the webinar and revert to each of you together or collectively, depending on the nature of the questions. Right, let's start with a quick refresher on the NEC4 on the NEC forms. First published in 1993 and last updated in April 2013, the NEC forms are an expanding family of contracts, which have been further augmented in the NEC4 suite, as we will show. They are increasingly the contracts of choice for public sector clients, particularly in the procurement of major infrastructure projects. Following on from the endorsement of NEC3 by the Office of Government Commerce, as it was then constituted in 2005, NEC4 is now commended for use in public sector projects by its successor, the Infrastructure and Projects Authority, which reports to the Cabinet Office and HM Treasury. This means that it is a safe decision for a public authority to select NEC4 ECC, or one of its companion forms, as the basis of procurement of its construction projects. Examples of some of the best known projects procured on the basis of earlier NEC contracts are shown on the slide. Now, the NEC contracts are intended for use globally and have been adopted enthusiastically by the public authorities in Hong Kong, New Zealand, parts of Africa and elsewhere. One of the NEC's stated aims in publishing NEC4 is to extend the global reach of the forms, with the bold and characteristic claim in the preface to the NEC4 suite that, to quote, NEC is unique in providing a complete back-to-back procurement solution for all works, services and supplies in any sector and any country. The preface to the NEC4 suite also boldly states that, again quoting, NEC has played a part in helping the industry to do things differently and better. It has done so by introducing effective project management procedures into the contract itself. These require proactive management of risk and change and the day-to-day use of an up-to-date program. The range of pricing options has given clients flexibility in the allocation of risk and the ability to share risk and manage it collaboratively. This philosophy is still at the heart of the NEC4 suite. So, as we mentioned earlier, the tagline for the NEC4 suite is evolution, not revolution. The preface states that there were three key objectives in drafting NEC4. First, to provide greater stimulus for good project management. Secondly, to provide support for new approaches to procurement which improved contract management. And thirdly, to inspire the increased use of NEC in new markets and sectors. Another aim of the amendments is to reduce the need for Option Z clauses. As we know, it has become very common for clients to rewrite the NEC form using lengthy amendments and Option Z clauses. We believe, in fact, that this will remain the case for the NEC4 suite, and we will explain briefly why. So there are now 16 contracts in the NEC4 suite, as detailed on this slide, including 4 new forms, as well as the established forms such as the engineering construction contract, the professional services contract, the SERM service contract, the framework agreements and so forth. NEC4 now includes new subcontracts to go with the term services contract and the professional services contract. It also includes a new design, build and operate contract and a consultative version of an alliance contract. So there is clearly a lot more to NEC4 than just the ECC and the PSC. So the new forms have been eagerly awaited. The NEC4 alliance contract has been in the pipeline for many years. It reflects the increased use of alliancing in the UK, particularly by Network Rail and the water companies, as part of their AMP circles. The consultation version is based on the Australian form of alliancing, which has been adopted in the UK by Network Rail in a number of large schemes. The alliance contract is to be entered into by all the key parties on the project, including contractors, who may be more than one, designers and the client. It reflects a number of the key NEC3 principles, but as is common with alliancing contracts, includes no formal dispute resolution mechanism. This reflects the no blame culture typically adopted on alliancing projects, with all disputes to be resolved by the alliance board. The consultation of the alliance contract is open until 30th of November 2017, so watch this space. It'll be interesting to see if this form is adopted for use on infrastructure projects. If so, we expect that it will be supplemented by the usual gamut of Z clauses, which we've become accustomed to in recent years. Now, the design, build, operate contract is intended to enable the client to procure the design, construction, operation and/or maintenance from one single client. This reflects the NEC seeking to expand into the engineering, procurement and construction and process plant market, where the use of forms such as ICHEME is more common. Finally, a professional services subcontract and a term service subcontract has been produced to fill gaps in the NEC suite. For more information about NEC4 PSC and the new PSS form, please log on to the webinar given by Will and Andrew yesterday, which is available to view on our website. As an integral part of the new suite of forms, the NEC guidance notes have been updated and consolidated. They are now provided in 4 distinct volumes for each form, dealing with procurement strategy, contract preparation, supplier selection, and contracts management, respectively. They are essential reading for anyone preparing, negotiating, or performing an NEC4 contract. Now, as could be expected following the introduction of the radically new NEC suite of contract forms in the early 90s, it took a number of years of their being tested in use before anyone took the plunge of litigating an NEC dispute in court. For quite a long time, the case of Bechtel and Costain in 2005 was the only NEC outlier to have been widely reported. This does not mean that there were no disputes under NEC forms, but there were plenty of disputes, but nearly all went no further than adjudication. In the past few years, however, there's been a steady stream of reported cases involving disputes under NEC contracts. We therefore now have the benefit of the court's views on these forms. Unsurprisingly, the NEC drafting style has prompted some judicial criticism, given the deliberate rejection of traditional drafting conventions by the NEC, including the general, albeit not completely consistent, use of the present tense rather than the future tense, which is the usual language of obligation, and the lack of cross-referencing between the clauses. So, for example, in the case of Atkins and Secretary of State for Transport in 2014, Mr. Justice Aikenhead referred to the loose language, which is mostly in the present tense, which can give rise to confusion as to whether and to what extent actual obligations and liabilities actually arise. However, in the same case, he acknowledged that NEC3 is highly regarded as providing material support to assist the parties in avoiding disputes and ultimately in resolving any disputes which do arise. Now, the 8 cases on NEC contracts that have gone all the way to judgment since 2010 repay close reading. They all apply to NEC4 as well as the earlier NEC forms, since the core NEC philosophy, structure, and approach to drafting have not changed. The basic structure of the NEC4 contracts, as I've just mentioned, has not changed. Each contract is made up of the core clauses, a main option, secondary options, W, X, and Y, and probably Z as well. The schedule of cost components, or the shorter of schedule of cost components, depending on which main option is selected, the contract data, and any additional Z clauses agreed by the parties. The scope, which is the new name for the works information, and the site information are the other essential components of an engineering and construction contract. A number of new core clauses and secondary option clauses have been introduced to reflect market practice, and there have been a number of drafting tweaks, including changes to terminology to ensure consistency across the suite. So in terms of changes to the terminology, the employer has now become the client. In the NEC view, in the NEC's view, this term is more generally used and understood in an international context. Now, reverting to the use of NEC2 terminology, the risk register and risk reduction meetings are now referred to as the early warning register and early warning meetings, respectively, in order to avoid any misconception that these provisions are in any way relevant to the allocation of risk between the parties. The works information is now the scope. Again, in NEC's view, scope is a very widely used and understood term, as well as being consistent with the terminology used in the professional services contract, albeit in the context of the scope of services rather than works deliverables. Another point to note is that the language used in NEC4 for the parties, including the project manager and the other actors, is now gender neutral. They are now referred to as it rather than he or him. This is a sensible modernisation of the forms to accord with best current practice. Now, the proactive management of risk is at the heart of the NEC philosophy, and at the core of this is the early warning regime. This has been upgraded as now more proactive rather than reactive. Within 1 week of the starting date, the first early warning register must now be prepared by the project manager, and an early warning meeting must be held within 2 weeks of the starting date. Further early warning meetings must be held at the interval stated in the contract data, rather than only one in response to the to an early warning notice. This is perhaps the best example of the NEC4 promoting good project management, and we have seen it imitated in other standard forms, most recently in the ACE professional services contract, which was published earlier this year. Now, while the risk register has no substantive impact on the allocation of risk between the parties, failure to give early warning of an expected compensation event could impact adversely on the later assessment of that event after it has been notified. On this note, I will hand over to James, who will now take you through the key changes to the provisions relating to programme, compensation events and dispute resolution.
Thanks, Tom. The specific changes I'm going to look at, as Tom said, are to programme, compensation events and dispute resolution and avoidance. So if we start with programme, a central ethos of the NEC suite of contracts is good project management founded on clear and effective communication. This impacts on matters such as identification and management of risk and time. The relevant core clauses for time remain in section 3. There is no change to the provisions for starting, completion and key dates. It remains part of the project manager's duties to decide the date of completion and to certify within 1 week of completion. Clause 31 contains the provisions for the programme. The accepted programme is defined as the programme identified in the contract data or is the latest programme accepted by the project manager. It remains that the accepted programme has contractual effect. As I will refer to later, it plays a significant role in the assessment of some compensation events. Therefore, the provision remains that if a programme is not identified in the contract data, it is for the contractor to submit a first programme to the project manager for acceptance. That programme is to be submitted within the period stated in the contract data. In this respect, Part 2 of the contract data is where any programme is identified, and if not, Part 1 of the contract data is where the period of time for the contractor to submit the first programme is identified. If the contractor does not submit a first programme and there is no programme identified in the contract data, then there is a new provision under clause 50.5 where 1/4 of the price for work done to date is retained in assessments of the amount due until a compliant first programme is submitted. This is to encourage the contractor to ensure that a first programme is in existence. So what is a compliant programme? Clause 31.2 sets out what the contractor must show on each programme submitted for acceptance. Aside from the general language change of scope from works information, these requirements remain the same. But as a new addition, the submitted programme is to be in the form stated in the scope. Therefore, when considering the contractual documents, it is important to verify and have included in the scope the required format. As contractors, this will allow you to ensure compliance with the first programme and any subsequent revisions, as well as the more obvious point that it is in a format that your project managers are comfortable with completing. A further new and important addition is in respect of deemed acceptance of the programme. Under clause 31.3 in NEC3, the project manager had 2 weeks to either accept a submitted programme or not accept it for one of 4 reasons. However, there was nothing that dealt with the project manager's failure to respond, other than the potential that it would be a compensation event under clause 60.16. This is now addressed in NEC4. If the project manager does not respond to a submitted programme within 2 weeks, then the contractor may notify the project manager of that failure. If the failure continues for a further week after the contractor's notification, the submitted programme is treated as accepted. Aside from the fact that this means no more 3-week holidays for project managers, it is interesting to note that a programme can be deemed to be accepted on the words of NEC4 even if it does not comply with the requirements of what it should contain under clause 31.2. In this regard, a deficient but deemed accepted program could impact on the operation of other clauses that rely on the accepted program, including the assessment of compensation events. An inability for the project manager to then assess compensation events could give rise to further disputes and complexity, which takes the focus away from doing the job. Therefore, it is important that the project manager responds within these 2 weeks to avoid such risks. In addition, if the contractor does not notify the project manager of the initial failure to respond within 2 weeks, then the program cannot be deemed to be accepted. As such, contractors must keep these dates in mind when submitting programs for acceptance. Clause 32 deals with revisions to the program. Clause 32.1 states the further information the contractor must show on each revised program. Interestingly, this no longer includes the effects of implemented compensation events and of notified early warning matters. It is unclear how this should form part of an updated program, and it may be that it forms part of the actual progress achieved. Under clause 32.2, it remains that the contractor submits a revised program to the project manager for acceptance, either within the period for reply after the project manager has instructed the contractor to submit such a program, or when the contractor chooses, but in any case at no longer interval than that stated in the contract data until completion of the whole of the works. However, in NEC4, nothing has been added as a further stick to force the contractor to submit a revised program, as the financial penalty I referred to before under clause 50.5, with the retention of a quarter of the price for work done to date, is not repeated in respect of later programs. The final change under time I want to raise in this webinar is in respect of acceleration, which is a more consensual approach now than under NEC3. It is now open to the contractor to propose to the project manager an acceleration to achieve completion before the completion date. Before, it was only open to the project manager to give an instruction to submit a quotation for an acceleration. If the contractor or project manager has proposed an acceleration, and if both are prepared to consider the change, then the project manager instructs the contractor to provide a quotation, stating changes to the key dates to be included. There are now time limits for the quotation and reply. The quote is submitted within 3 weeks of the instruction, and the project manager replies within 3 weeks, we presume, of receipt of that quotation. When a quotation for acceleration is accepted, the project manager chooses the prices, key dates, and completion dates accordingly, and accepts the revised program submitted by the contractor with the quotation. This change allows a proactive and forward-looking contractor the opportunity to make proposals to speed up a project. This not only can benefit a project, but can assist in building long-term trust and relationships with the ultimate client. It is also part and parcel, as we see it, with the contractor acting in a spirit of mutual trust and cooperation for the benefit of a project's success. Turning now to changes to the compensation event procedure. Again, there are some changes of terminology. For example, employer's risk in clause 60.414 is now client's liability. There are 2 new compensation events which have been added to the core clauses. Firstly, under clause 60.120, it is now a compensation event if the project manager notifies the contractor that a quotation for a proposed instruction is not accepted. This relates to the new clause 65 in respect of proposed instructions, and so entitles a contractor to recover costs of preparing quotations for such proposed instructions that are not accepted. Under clause 60.5, the project manager may instruct the contractor to submit a quotation for a proposed instruction, stating the date by which the proposed instruction may be given. Importantly, this does not entitle a contractor to put a proposed instruction into effect. It must go through the quotation procedure first. The contractor submits the quotation within 3 weeks of being instructed to do so, and it is assessed as a compensation event. The project manager replies to the quotation by the date when the proposed instruction may be given. The reply is either an instruction to submit a revised quotation with reasons, issue an instruction with notification that it is a compensation event and the quotation is accepted, or notification that the quotation is not accepted. It should be noted that unlike the deemed acceptance of a program, if the project manager does not reply to the quotation within the time allowed, the quotation is not accepted. However, it remains under clause 60.16 that it is a compensation event if the project manager does not reply to a communication from the contractor within the period required by the contract. If the quotation is not accepted, then the project manager may notify the proposed instruction as a compensation event and instruct a quotation for that. The second new core clause for compensation events is an express reference to specific and agreed compensation events that are stated in the contract data, Part 1. This allows the parties to consider risk related to a specific job and, where appropriate, for a contractor to attempt to negotiate the inclusion of such risk as compensation events into the contract. This gives a more focused approach to specific risks, including in respect of the contractual matrices between all parties, including consultants, and, as Tom touched on earlier, avoids the need for excessive Z clauses. There is now a slight change to the procedure for notifying compensation events. Where a compensation event arises from the project manager or supervisor giving an instruction or notification, issuing a certificate or changing an earlier decision, the project manager notifies the contractor of the compensation event at that time and includes in the notification an instruction to the contractor to submit a quotation. The exceptions to this are if the event arises from the fault of the contractor or the event has no effect on defined cost, completion, or meeting a key date. Clause 60.1 still governs notifications by the contractor of an event which has happened or is expected to happen as a compensation event, and which the contractor believes is a compensation event which should have been notified by the project manager but has not. However, in place of the 8-week period to notify after being aware of the event, there is now an 8-week period to notify only an event that has happened. It is not clear what the notification period is now for an event that is expected to happen, presumably only when it does. However, it is our view that it's best practice to notify events that are expected to happen promptly as well, so that it's on the radar of the parties and consideration can be given as to any instructions or acceleration that could assist in avoiding the event happening. In addition, failure to notify within the 8-week period has the same results as NEC4. No changes to the prices, completion date, or a key date. The exception to this is no longer those events that the project manager should have notified but did not, but now only relates to those events which arise from the project manager or supervisor giving an instruction or notification, issuing a certificate, or changing an earlier decision. When assessing compensation events, there is now a dividing date. For compensation events that arise from the project manager or supervisor giving an instruction or notification, issuing a certificate, or changing an earlier decision, the dividing date is the date of that communication. For other compensation events, the dividing date is the date of notification of the compensation event. This is important for considering actual against forecast defined cost in clause 63.1 and identifying the relevant accepted program for considering any delay to the completion date caused by a compensation event under clause 63.5. In addition to the change to reflect the dividing date, clause 63.5 also now includes that in an assessment of delay, only those operations which the contractor has not completed and which are affected by the compensation event are changed. Therefore, assessments cannot retrospectively alter the completion date for work done by the dividing date. As above, by the introduction of a dividing date, a contractor should closely monitor progress and submit revised programs for acceptance as necessary. Any delay in doing so may give rise to inadequate assessments of delay by the project manager, as he or she is basing the impact of a compensation event on a program that may be out of date. Importantly, under clause 63.8, the assessment of the effects of a compensation event includes risk allowances for cost and time, which have significant chances of occurring but are not themselves compensation events. And finally, under clause 63.9, the assumption in NEC4 that the accepted program can be changed is now deleted. Finally, I'm going to look at changes to the dispute resolution procedures under NEC4. The first change to note is the title of the slide itself. It is now called Resolving and Avoiding Disputes. And as I explained, this change reflects the ethos of resolution by discussion and cooperation rather than by adversarial methods to avoid disputes. This again promotes collaboration and mutual trust and cooperation. It should be noted that avoiding formal disputes under NEC3 has been largely successful, as Tom touched on, at least in respect of reported decisions. NEC4 endeavours to build on this. The options for disputes are W1 and W2 as before, and a new W3. W1 is used when the Construction Act does not apply, and so the UK mandatory adjudication provisions do not apply. W2 is used where the Construction Act does apply, and so the new procedure of referring disputes to senior representatives is not a mandatory step before a party can adjudicate. W3 is used where a dispute avoidance board is the method of dispute resolution identified in the Contract Data Part 1, and the Construction Act does not apply. For the purposes today, I'm going to discuss the changes to W2, but I'd be happy to answer any questions on W1 or W3 following this webinar. As I've mentioned, there is the new option of seeking to resolve disputes by way of referral to senior representatives. This is not mandatory in W2. The senior representatives of the client are identified in the Contract Data Part 1, and the senior representatives of the contractor are identified in Contract Data Part 2. They should not be involved in the day-to-day operations of the project and be of sufficient seniority to negotiate a binding settlement. The first step is for the parties to agree to the referral of a dispute arising under or in connection with the contract to the senior representatives. As such, there can be no ambush of the senior representatives by one party, or a dispute being commenced at perhaps an inopportune moment for the project, or indeed the individuals who make up the party's senior representatives, which can occur in adjudication. Whether this is a good or bad thing will depend on the dispute and the working relationship between the parties at the time the dispute occurs. If the dispute referred is not resolved by the senior representatives, then it is referred to and decided by the adjudicator, who is also named, or at least should be, in the Contract Data Part 1. The party referring the dispute notifies the senior representatives as well as the other party and the project manager. The notification must set out the nature of the dispute. Within 1 week of the notification, the parties submit to each other their statements of case. These are to be a maximum of 10 A4 pages, plus any supporting evidence, although the parties can agree differently. Senior representatives then meet as many times as necessary and using any procedure they consider appropriate to try and resolve the dispute over a period of up to 3 weeks. At the end of the 3-week period, the senior representatives produce a list of the issues agreed and not agreed. The issues that have been agreed are put into effect by the project manager and contractor. This procedure is done on a without prejudice basis. Documents produced cannot be used or referred to in any subsequent proceedings before the adjudicator or tribunal. The aim is to have a degree of independent thought and consideration of issues, including seeing any bigger picture that those involved in the day-to-day management of the project may not be able to see. It also should remove the potential for personal animosity between those with the day-to-day management of the project dictating a party's response to a dispute. What is not clear is how either party can introduce evidence from the project manager. This may be of more concern to the client when the dispute arises from the project manager's decision that they may have no knowledge or input to. We suspect that the use of any evidence from the project manager will be incorporated into the procedure agreed by the senior representatives at the outset of the referral. As above, this process does not end a party's right or is a precursor to a party's right to adjudicate. They can still adjudicate at any time. This is reaffirmed in clause W2.2.1. For any adjudication referred, there is very little change to the timetable, save that the time for the adjudicator correcting any clerical errors or typos have been reduced from 14 to 5 days. The procedure remains the same in that it is drafted to be compliant with the minimum requirements of the Construction Act and the Scheme for Construction Contracts. It remains that a single adjudicator should be appointed at the outset and their appointment lasts for the duration of the project. This is set out in Contract Data Part 1. Provision will also be made for a nominating body if that adjudicator is unable to act. The adjudicator takes no part in the project unless a dispute is referred. This is in contrast to a disputes board where the board members are regularly involved. The adjudicator can only deal with a dispute referred to him. In reality, this is no different to the jurisdiction of adjudicator under other contractual or statutory adjudication process. However, by new clause W2.27, it is expressly stated that a party does not refer a dispute that is the same or substantially the same as one that has already been decided by the adjudicator. Following the case of Quietfield against Vascroft Contractors in 2006, it is a question of fact whether the dispute referred to adjudication is the same or substantially the same as a dispute already decided by an adjudicator arising out of the same contract. The Court of Appeal has stated that the starting point is the adjudicator's own view regarding whether one dispute is the same or substantially the same as a previous dispute. Obviously, this is aided under NEC4, where the same adjudicator should be appointed on all adjudications. Again, it remains that the adjudicator's decision is interim but binding. As such, the parties must implement the decision until they agree otherwise, or the dispute is finally determined by the tribunal, and the adjudicator must give reasons for his or her decision. It remains that the adjudicator's decision is due within 28 days of the referral, extended by 14 days with the agreement of the referring party, or longer if all parties agree. It should also be noted that the adjudicator can decide a dispute under the ECC and a dispute under a subcontract together if the subcontractor so consents. In reaching a decision that includes an assessment of additional cost or delay caused to the contractor, the adjudicator must make his assessment in the same way as a compensation event is assessed. By way of a new addition, where the decision changes an amount notified as due, the date on which payment of the change amount becomes due is 7 days after the date of decision. This puts into the NEC4 contractual procedure the norm for adjudication awards to be paid within 7 days. To challenge an adjudicator's decision, a party must serve a notice of dissatisfaction. There are time limits for taking this step, subject to agreement between the parties. Under W2.42, a party must serve a notice of dissatisfaction within 4 weeks of the decision to be able to refer the dispute to the tribunal. The last resort for any such disputes is the tribunal, court or arbitration. It still remains under clause W2.4 that a party must have a dispute decided by the adjudicator before it can be referred to the tribunal. In any event, this would be the case for any enforcement proceedings, but as drafted includes a claim for a final decision on an issue. The tribunal, again court or arbitration, is identified in the Contract Data Part 1. In this regard, there remains the difference in drafting with W1, which allows the party to refer a dispute to the tribunal once it has been referred to the adjudicator, i.e. a decision is not necessary. However, W2 has stuck by its previous procedure that an adjudicator must make a decision and that decision be challenged by a notice of dissatisfaction before it can go to the tribunal. I will now pass you back to Tom, who will update on some of the other key changes in NEC4.
Thank you, James. Now, in relation to contractor design, as under NEC4 ECC, the contractor is likely to be subject to an uninsurable fitness for purpose obligation unless option X15 is incorporated in the contract. So a reference to option X15 in the first entry of the contract data should therefore be one of the first points for the contractor to check in any contract which involves it undertaking any element of design. Where option X15 is incorporated, it no longer requires the contractor to prove that it has used reasonable skill and care to ensure that its design complies with the works information. The unreversal of the burden of proof, such that the normal rule applies that it is for the claimant to prove negligence or breach, must be seen as a positive change for contractors, given the difficulty of building a positive case of compliance on the basis of records that are likely to have been prepared years previously and the evidence of witnesses who may no longer be available. I'm aware of at least one case which was significantly prolonged as a result of the contractor having to discharge this burden of proof, although ultimately the contractor was in fact successful in establishing that it had used reasonable skill and care. Now, the reference to the skill and care normally used by professionals designing work similar to the works is now consistent with the duty of care required of consultants appointed under NEC4 PSC. The exact meaning of these words is yet to be tested in the UK, since they are not as tried as tested as the usual formula of reasonable skill and care, which are the words ingrained in every professional indemnity insurance policy. Given that normal professional practice is used as a benchmark by the courts when considering professional negligence cases, the NEC formulation is likely to be construed as having the same effect, although no doubt we will see interesting arguments that different words should be given different effects. As regards professional indemnity insurance, under NEC3, where the employer required the contractor to maintain PI insurance, it had to be identified in the contract data as an additional insurance to be taken out by the contractor. In practice, it was invariably dealt with as an option Z clause. Now, clause X15.5 provides that the contractor must provide insurance in the minimum amount stated in the contract data from the starting date until the end of the period stated in the contract data. Typically, this will be 12 years from completion. It is normal in other contract forms to include a proviso with the effect that the contractor is not required to maintain the required level of PI insurance if it is no longer available at reasonable premium rates and on reasonable terms. Option X15 does not include this proviso, and this entails a significant risk to the contractor, particularly in view of clause 85 of the core clauses, which provides that the client may insure an event or liability which the contract requires the contractor to insure if the contractor does not submit a required certificate. This risk is particularly serious given the long-term nature of the typical PI insurance requirement and the sensitivity of the insurance market to trends in claims. We may see, for example, a surge in insurance claims and a commensurate increase in insurance premiums as one of the consequences of the tragedy at Grenfell Towers. Contractors will therefore be well advised to seek an option clause amendment, including for the usual reasonable premium rates proviso and reflecting any other terms of their PI policies. For example, if there are exclusions or aggregate limits which are applicable to such matters as pollution, contamination, and dates recognition claims. As regards the retention of documents, clause X15.4 provides that the contractor must retain copies of drawings, specification reports, and other documents which record the contractor's design for the period of retention stated in the contract data. We anticipate that typically this will be for the duration of the contractor's liability, i.e. normally 12 years from completion. The form in which the documents are to be retained is also to be stated in the contract data. As regards payment, under NEC3 engineering construction contract, the project manager has to consider any application submitted by the contractor on or before the assessment date. But the contractor is under no obligation to submit an application payment in order to be entitled to payment. In practice, of course, contractors invariably do submit applications for payment, even on the smallest project. This is now a requirement under clause 50.2. If the contractor fails to do so, the amount due is the lesser of the amount assessed by the project manager to be due, and the amount due at the previous assessment date. So the amount due will either be zero or a negative amount, which must be paid by the contractor. This is obviously a compelling incentive for the contractor to submit an application for payment if one is needed. NEC3 did not include any specific provision for the assessment of the final amount due to the contractor. There is therefore the potential for negotiations and ultimately disputes to be protracted indefinitely before the final payment is made. This is obviously inconsistent with the NEC philosophy of dealing with issues rapidly. Under the new clause 53 in NEC4 ECC, the project manager must make an assessment of the final amount due and certify a final payment no later than 4 weeks after the supervisor issues the defect certificate, or 13 weeks after the project manager issues a termination certificate where there's been a termination. The final payment is to be made within 3 weeks of the assessment, or within the period stated in the contract data if different. There is a default procedure for the contractor to make its own assessment if the project manager does not make an assessment within the time allowed, and this amount becomes payable if it is agreed by the project manager. The assessment is conclusive evidence of the final amount due unless a party refers the matter to the dispute procedure within the time limits prescribed by clause 53. In options C to E, there is now a main option clause which prescribes a procedure for the finalisation of defined cost. The contractor must first notify the project manager when a part of defined cost has been finalised and make available for inspection the records necessary to demonstrate that it has been correctly assessed. The project manager must then review the records which have been made available, and no later than 13 weeks after the contractor's notification either accept that part of a defined cost is correct, or notify the contractor that further records are needed, or notify the contractor of errors in its assessment. The contractor must provide any further records requested, or advise the correction of the errors in its assessment within 4 weeks of the project manager's notification, where the defined cost has not been accepted as correct. The project manager must review the records provided and within 4 weeks accept the cost as correct, or notify the contractor of the correct assessment of that part of defined cost. If the project manager does not notify a decision on that part of defined cost within this period, the contractor's assessment is treated as being correct. However, it should be noted that the dispute resolution procedure gives the project manager a get out of jail card, which applies to its actions or inactions generally. Of course, there's no corresponding get out of jail card for the contractor if it fails to take an action required by the contract, for example, to notify a compensation event within the 8 weeks required by clause 61.3. Now, there are some important changes to the schedule of cost components, which is the basis for defining defined cost in options A and B, and what is now referred to as the short rather than the shorter schedule of cost components, which is the basis for assessing defined cost in options C, D, and E. In both the schedule and the short schedule, the percentages applied under NEC3 to various costs, including working areas, design as a contribution to overhead costs, have been removed. So the fee percentage will now need to allow fully for all overhead costs, along with all other costs not included in the schedules of cost components. Now, NEC4 reverts to a single fee percentage, so there is no differentiation, as there was under NEC3, between the direct fee percentage and the subcontracted fee percentage. This should simplify the bidding process and assist in the transparency and comparability of bids. Finally, where options A and B apply, the cost of people within the working areas and the cost of manufacture will be assessed by reference to time charge rates to be provided by the contractor in the contract data part 2, rather than by reference to amounts actually paid by the contractor. In effect, this is a traditional day works approach, which again should aid transparency and simplify the administration of options A and B in the short schedule of cost components. Now, Section 8 has been significantly revised, partly in response to concerns raised by insurers. Under NEC4, all risks other than those which are not specifically listed as employers' risks are contractors' risks. This has the somewhat nonsensical result that most of the compensation events, such as exceptional weather measurements and unforeseen physical conditions, as specified in Clause 60, are contractors' risks and are therefore covered by the universal indemnity by the contractor to the employer in Clause 83 of the 3rd edition. Now, under NEC4, any employers' risks and contractors' risks have been rebadged as employers' liabilities and contractors' liabilities, respectively. And the contractors' liabilities have now been itemised in an exhaustive list, which includes third-party claims arising from the works, loss or damage to the works, loss or damage to the property owned or occupied by the client other than the works, and death or bodily injury to the employees of the contractor. Now, including an exhaustive list like this is definitely an improvement, particularly as the contractor's liability items should be covered by insurance. Although, of course, contractors will need to check with their insurers that their policies will in fact respond to these claims and losses. The indemnity language in Clause 83 has been replaced by recovery of costs wording in Clause 82. But in my view, the wording is likely to be construed as being similar in effect to an indemnity. So there is no significance to the improvement in the position for a contractor. So there is no significant improvement to the position for contractors here. I discussed the new requirement for professional indemnity insurance in my discussion of option X15 earlier. So looking at a few other changes to the contract. Under Clause 16, the contractor is now incentivised to propose value engineering savings. If the contractor's proposal is accepted, the project manager issues an instruction changing the scope. This is then treated as a compensation event in the usual way, except that importantly, for options A and B, the reduction in the prices is calculated by applying what is known as the value engineering percentage to the cost saving. This will be 50% unless otherwise stated in the contract data. So in this case, the contractor will keep 50% of the saving. For options C and D, the price is not reduced, but this of course means that any cost savings are divided between the contractor and the client in accordance with the contractor's share. Now, where option X21 is selected, the contractor may propose a change to reduce the cost of operating and maintaining an asset. If it is accepted, it is a compensation event, but the project manager changes the scope, prices, completion date, and key dates accordingly, and accepts the revised program proposed by the contractor. Here, the assumption must be that the cost of the works will be increased, but the cost increase will be more than outweighed by the whole life cost saving of operating and maintaining the asset. So looking briefly at a few other new provisions to note, I'm not intending to run through each of the new provisions noted on this slide in any detail. Any contractor tendering for an NEC4 engineering construction contract will need to review these provisions thoroughly. I would categorise them as new provisions to reflect law and current market practice. Corrupt acts falls into this category. New provisions of government policy in relation to the management of public sector projects. Information modelling falls into this category, given that the use of BIM is mandated in relation to public sector projects. New provisions to reflect common employers' requirements, for example, disclosure, quantity management, and undertakings, which is the term given by NEC to collateral warranties, all fall into this category. Provisions previously issued by the NEC as a loose leaf supplement, early contractor involvement, falls into this category. And new provisions which do not substantively alter the position under NEC4. Assignment falls into this category, as there are no real restrictions on either party's right to assign the benefit of the contract. I have also noted on this slide that termination by the client for convenience has been moved from core clause 90.2 to secondary option X11. This is an improvement from the contractor's point of view, insofar as the client now needs to make a positive choice to have this facility. It brings it out into the open and gives the contractor the opportunity to interrogate this requirement at tender stage. So I'm briefly going to have a look at the engineering construction subcontract before bringing the webinar to a close. Now, as could be expected, the same approach has been adopted to the drafting of the NEC4 engineering construction subcontract, as was taken in relation to 3rd edition, in that the key changes to the ECC have been replicated, with few exceptions, in the ECS. Given this approach, the NEC have not considered it necessary to introduce a general obligation on the subcontractor not to put the contractor in breach of the main contract. Many contractors will no doubt continue to include a standard option Z clause to this effect, with all the usual bells and whistles. A new provision to note is clause 91.9, under which the contractor may terminate if his obligation to provide the works in the main contract has been terminated. The effect is similar to termination for convenience under new secondary option X11, including the right to the fee percentage on the unused prices. Given that the contractor will not be compensated for loss of profit in most cases if the main contract is terminated, contractors will need to consider whether clause 91.9 should be deleted and replaced with a Z clause, which deals with the consequences of termination in a less potentially detrimental way. So, drawing a few conclusions, we would give a guarded welcome to NEC4 engineering construction contract. It includes a number of improvements from the contractor's point of view, including the provisions we have summarised for deemed accepted programme, assessment of final amount due and final defined cost, the unreversal of burden of proof in relation to design liability under option X15, and the reversion to a single fee percentage, and the simplified administration of the short schedule of cost components. There are useful new options to reflect current practice and common employer or client requirements in relation to collateral warranties and information modelling and so forth. We do, however, expect a significant number of Z clauses to continue to be included in the NEC forms for the reasons we've given. Now, the contract remains administratively onerous. Even more than under NEC3, it will be important to be proactive and to ensure that adequate management resource is allotted to your project. For example, in relation to the more entrenched system of early warning meetings. As with any contract, it is vital that contractors read and understand their NEC4 contracts. If they're left in the drawer, it will be too late to retrieve the position if the procedures in relation to such matters as early warning and compensation events are not followed. Now, I'm just going to highlight an approaching webinar which is to take place on the 2nd of August, and James Hutchinson will be delivering a webinar on this date on the general data protection regulations, which come into effect from 25th May 2018. The topics which will be covered in that webinar are set out on this slide. So it remains for me to say thank you for listening to me and James this afternoon. If you have any queries in relation to any of the items we've discussed, or on the ECC or new NEC4 suite generally, please do not hesitate to contact us on the details shown on the screen. Once again, thank you for listening.